George Gryllos, Alba Ribera Martínez, Marco Botta. Welcome to Digital Markets Research Hub. We will be discussing today the DMA, and obviously one of the most topical issues is compliance reports, the first non-compliance investigations launched by the Commission, and it's hard to resist the temptation to have a look at these issues. But we decided to focus on more juristically refined problem, long-standing problem, namely the relationship or delineating the boundaries between the DMA competence and other areas of law, EU law, namely competition law, and national law. And we're here talking about national competition law, national law regulating unilateral conduct, broader, and also other areas regulating the conduct of designated conduct of gatekeepers. So it's quite a labyrinth, and I'm very grateful for the opportunity to discuss these intricacies with you, because you are very familiar with all these peculiarities, and we can hypothesize, obviously, but we will start with scrutinizing the letter of law. Before doing this, however, I wanted to mention that last year we conducted a topic or a panel on similar issue with Giorgio Monti, Or Brook, and Magali Eben. So if people are interested in looking further at this issue, you are very welcome to check it. In the commentaries, you have the links to all the sessions. So the starting question, maybe I'll start with you, George. What, in your view, be the ideal vision in trying to demark the boundaries between the DMA and other mechanisms regulating very similar relationships? What would be the ideal formula in your view?
First of all, I think that the ideal formula is for the DMA to work in the same way as dozens of other measures adopted by the European Union that aim at harmonizing national laws. So the DMA is a harmonization measure that, as I understand it, is designed to fit in a much greater puzzle that regulates the activities of certain operators. So the ideal is that the DMA is a piece that fits perfectly in the spot it was intended for. And therefore, we have no overlaps, no conflicting elements with either with other measures, like, for example, the GDPR or the platform to business regulation, or indeed with national law, although the latter conflicts can be quite easily resolved on the basis of well-established principles. I would dare to think that based or subject to a correct interpretation of the DMA, that objective can be attained if it is not already so. And we can, of course, discuss more details as our discussion progresses.
Thank you, George. Alba, how would you define it, please?
I would say, first of all, I would maybe agree to disagree with George in the sense that no overlaps and conflicting elements resulting from the DMA and the collision with national law may not be quite real in practice, in the sense that it is inevitable to have those overlaps, and national law will surely collide with the DMA and how it applies to the gatekeepers. But I would say, as also George already said, that we should maybe look to the recitals on how to interpret the DMA's provisions. For example, this wish to address fragmentation in the internal market via the setting out of these appropriate regulatory safeguards to secure these internal and harmonized digital markets. And also, whilst reading and preparing for the conversation, I stumbled upon a recital that sometimes it gets forgotten, recital 8, which establishes that the DMA is also aimed at eliminating the obstacles to the freedom to provide and receive services within the internal market, which is really maybe conflictive with the situation that we have now, because in practice, as we will discuss later on, it may be quite difficult to attain that objective. And I also would say that the main locus or the main focus of the DMA would be to go back also to recital 91, I think it is, with the European Commission being the DMA sole enforcer, and then the NCAs have to support and sustain a secondary role in helping out the European Commission in its enforcement efforts. And I would say that would be the outset of the institutional setting of the DMA.
Thank you, Alba. Marco?
First of all, thank you all for the invitation to the webinar. I'm very happy to be here to discuss this topical subject. I fully agree with Alba. So the starting point of the DMA is to avoid the fragmentation of the internal market. So we are in 2020 when the Commission came out with the DMA proposal. After the series of studies carried out by different national competition authorities and also by the Commission on the needs and how to regulate the digital markets because of their specificities. But then clearly there was a political tension. So if all the member states start to adopt a separate sector-specific regulations on digital platforms, we will have a fragmentation of the internal market. So if we talk about the ideal world, as academics usually talk about that, we would have only the DMA in place. We would not have any national law regulating the work of digital platform and specifically the gatekeepers, at least when we talk about the core platform services. As we will see, this is not the case in reality.
And let us now move to more to reality. And here I imagine, George, you could start with somehow articulating what the co-legislators have managed to achieve with mainly provisions of Article 1.5 and 1.6, but also some others as well.
Yes, well, as I see it, and this is the case with every harmonization measure, there are fields that are harmonized and fields that are not harmonized by that measure. So there are always boundaries, and we can see that also in the treaty and in the relevant protocol. When the Union takes the initiative to harmonize a sector, there are activities that fall within the scope of the harmonization and other activities that do not fall within that scope. So since we are talking about a shared competence here, which is the functioning of the establishment and the functioning of the internal market, it is inevitable that the legislator, as a simple matter of good legislating practice, they have to decide how to articulate the relationship between the harmonized and the non-harmonized parts of the activities. So in the very first article of the DMA, this is set out in paragraphs 5 and 6, where the legislature has set out exactly what is being harmonized and thereby what member states can do without stepping into the scope or without compromising the scope of that harmonization. We have to remember always that the DMA was adopted on the basis of Article 114 of the treaty. And thereby it is a harmonization measure that, exactly as Marco and Alba said, is designed and is designed in order to address the risks of fragmentation that have been identified and invoked in order to trigger the application of Article 114 of the treaty. So in order to do that, in a legal fashion, the DMA had to truly harmonize and thereby exclude member states from legislating within the scope of the DMA. But it also has to define which areas are not harmonized and thereby left with the member states, which can legislate, subject, of course, to observing all the principles and other rules of EU law. It is not a vacuum. Outside the DMA, we don't have a vacuum. So we have, for example, paragraph 5 and paragraph 6, which are also related to each other. And as I understand it, for example, paragraph 6b, where I would start, allows member states to apply national competition rules that prohibit other forms of unilateral conduct insofar as they are applied to undertakings other than gatekeepers. That is pretty straightforward. If you're not a gatekeeper, you're not within the scope of the DMA, or amount to the imposition of further obligations on gatekeepers. And it is this part, what does further obligation means exactly, that is the most important in my view. Once we define this correctly by saying that further obligation means obligations that do not intersect in any way with the obligations imposed by the DMA, then, in my view, it is clear that national legislation is within the scope of Article 16b and can apply to a gatekeeper because it regulates parts of their activity that do not intersect with the DMA. That is how I understand Article 16b read in the light of the relevant recitals. I could go on, but I would prefer to stop here.
With a caveat that it's not as straightforward, yeah? In the sense that in reality, we don't have such a clear-cut separation.
Nothing is straightforward today anymore. But I think this is something that can be figured out normally in every single situation.
Okay, thank you, Giorgio. I'll move to Alba.
Yes, so we can also up the gauntlet from Marco, stemming from this pre-DMA scenario. We also have to take into account, and also going back to Giorgio's point on 114, that the real elephant in the room when passing the DMA was that of harmonizing the internal market based on this legal basis of Article 114 because of the political configuration and the wishes of the co-legislators to intervene. Because if the DMA was to be passed via the competition regulation basis, then an unanimity would have been required and the European Parliament would have not intervened in the legislative process. And this is quite substantive for I would say three fundamental reasons: the fact of having this 114 legal basis alongside the article that Giorgio already highlighted around Article 16. First, that as opposed to Regulation 1/2003, the DMA is a centralized system of enforcement vis-a-vis Regulation 1/2003, which is a decentralized system of enforcement. So this is also quite salient in the sense of the coordination and the cooperation efforts that must apply to the relationship between the European Commission and the national competition authorities. Also, Article 114 also brings this idea that the enforcement action that the European Commission must apply must also be guided by this principle of proportionality. So it is also really important, and maybe we can get back to this same point on the point of the appeals that the gatekeepers posed before the General Court on their designation decisions, because the European Commission has also to bear in mind and apply this principle, and also aside and maybe on top of this idea of the differentiation between both types of regulations, we have that many of the provisions of the DMA, aside from 1.5 and 1.6, and maybe we have a similar provision under 1.7 and similar provisions under Articles 37 and 38 that set out the coordination and the cooperation rules to apply between the European Commission and the national competition authorities that mimic the wording from Regulation 1/2003. And by mimicking that wording, sometimes we have the I would say the contradiction that some of the wording and the meaning within Regulation 1/2003 does not fit perfectly with the wording and the language and the legalese of the DMA. So we also have some source of conflict there. And I also wanted to highlight this this obligation also imposed on the national competition authorities, also on the national courts, that their interpretation of the DMA shall also be uniform and uniformly applied. And there's also prominence of the European Commission's interpretation in applying these provisions, maybe even as a more prominent position as the primus inter pares position within the Regulation 1/2003, and on the interpretation, finally, on the interpretation of Georgia's Article 1.6, I would say that it is quite significant to know how to interpret. Maybe it is not perfectly clear provision, because now we are also seeing that national competition authorities are indeed initiating sanctioning proceedings against undertakings that are not, as of now, gatekeepers, but that they might be designated as gatekeepers in 2 months' time, such as, for example, the Spanish competition authorities case against Booking. And this is quite salient because the European Commission has been quite, I would say, vocal or adamant in defending that antitrust is for the past and the DMA is for the future. So I would be quite, I don't know, quite careful in defining quite well this past and future, because now maybe the sanctioning proceeding comes and the fines come just after, for example, Booking is designated as a consequence of the Spanish competition authorities intervention. And I think that also the Italian competition authorities also triggered an additional sanctioning proceeding against Booking for similar reasons that may be also captured via the DMA. So I would say that the interplay is quite interesting at this point.
But just to clarify, as long as it's traditional competition toolkit, national competition toolkit concerns, there is no prejudice of the DMA, yeah, as we understand, unless they do it in a kind of speedier, more expedient way, like Section 19A.
But then I would say, first, if we are going to go into detail with Section 19A, we should also bear in mind that although it's a similar instrument to the DMA, it is competition law. So we must first categorize it as such, and then I would say that it is without prejudice, but as we have seen in practice, there may be some grounds for cross-fertilization on the scope and the obligations that may be imposed on those undertakings, although they are not designated, although they are not subject to the DMA.
Thank you very much, Alba. Marco, what are your views on this?
So I spoke before about the ideal world. So what is the world in reality? In reality, we see in Article 1, I think, 3 types of possibilities for member states to intervene in this field. So one is Article 1.5, which mentions the possibility for the member states to adopt other legislations also concerning the gatekeepers, and paragraph 9 of the preamble specifies that these national rules should pursue legitimate public interest objectives as mentioned in the treaty, or overriding reasons of public interest. So I'm thinking about reasons of public security, public health. I don't know, member states adopt new rules on cybersecurity, for instance, and there is no harmonization at the EU level, and they impact the work of the gatekeepers. Or we have a new pandemic, hopefully we will not have it, and member states, in order to detect the different cases, they adopt rules that force the gatekeepers to cross-use data across the ecosystem in order to identify, I don't know, areas where new cases are coming out, okay, in breach of Article 5, Paragraph 2 of the DMA. So this is, I would say, Article 1.5, it's, we say, quite exceptional. It exists in every EU law. There is always the possibility for the member states to derogate in this type of scenarios. Then we have the competition law, so which can be applied in parallel to the DMA, because at least formally the DMA has different objectives to competition law, so consumer welfare versus contestability and fairness of digital markets. It's clear that the principle of ne bis in idem will be applied, let's say, to avoid a replication of the sanctions that the Commission can impose under the DMA in comparison to the sanctions that can be imposed under national competition rules. Personally, I don't think we will have really a lot of problems in this field. For what the Commission has been repeating in the last weeks during the compliance workshop, the competition law is about the past conducts, the DMA is about the future. So I don't think the Commission will really investigate new cases of abuses about the digital gatekeepers, at least when the abuses fall within the scope of the DMA obligation. Clearly, we can envisage a situation in a couple of years when these obligations mentioned in Article 5 and 6 becomes outdated. And rather than updating the DMA rules, the Commission will rely on Article 102, which has a more dynamic and open concept of abuse. So I would say this could be a second scenario where national competition authority could especially sanction a case of abuse of dominance, even by the gatekeepers, in case the abuse fall outside the scope of the DMA obligation. I would say that. And then we also have the third scenario, which is that one mentioned before by George. So Article 1.6b, that allows the member states to sanction other forms of unilateral conduct, let's say. I'm thinking about scenarios of, I don't know, all the national rules about economic dependence, let's say. Also, Section 19A of the GBB would fall under this type of exception. Paragraph 10 of the DMA preamble mentioned that this type of scenario takes place when the national rules sanction unilateral conducts that are based on individual assessment of the market position of the parties, and allow the undertakings to make efficient and objective justification to their conduct. This is exactly the case for Section 19A of the GBB, where the designated platform can let's say, rebut, let's say, the breach of the 7 obligation in Section 19A by putting forward objective justification, something that does not exist under the DMA. And as Giorgio mentioned, it's possible, let's say, in 2 scenarios, let's say, to apply these national rules that sanctions other forms of unilateral conduct. So the first scenario is when a company and undertaking is not a gatekeeper, so it's outside the scope of the DMA. For instance, we have a designated gatekeeper, but we have I don't know, a case concerning non-core platform services, let's say, or the national rules impose further obligations over the gatekeepers. And this is in line with what I was saying before about abuse of dominance. So the National Competition Authority can sanction cases of abuses that fall outside the scope of the DMA obligation. So these are, in my opinion, the three exceptions to the general rule that the DMA is there to prevent fragmentation of the internal market, and therefore member states should not have national rules in this field.
Let me pause here and maybe George ask you and then Alba and Marco. Section 19A epitomizing this kind of trend, which we sense from some member states at least, who want to have either safety net or maybe more prominent role already in shaping competition in digital markets. So there is no second reading about it. It definitely belongs to Article 16A, Article 16B, not Article 16A. You all agree on this, yeah? And what would be the difference shifting it? Is it the one limit outlined by Marco in his previous answer? So only the individualized, the efficiency defense and individualized designation, or defining the unilateral conduct, unlawful unilateral conduct. And if this is the case, so does it mean that the legislators, assuming that they were driven by the intention to somehow to introduce more refined and more robust unilateral abuse of dominance rules, that they didn't do they decided to stop in the middle of the road? Or why did they introduce efficiency defense to this matrix, so to say?
Let me just make sure I understand the question. The question is why there is no individualized assessment or an efficiency defense in the DMA. Is that your question? Or
no, I rather allude to the scenario if national competition national authorities can adopt stricter abuse of dominance rules, why they have opted for adopting section 19A for the path which would categorize them to 61B rather than doing it within 61A somehow, which allows which would allow them being exempted from DMA, or not being prejudiced by the DMA.
Let me just say this. As I understand, and then I will speak with an example, because maybe in that way we can make things more perceptible. In Article 1, Paragraph 6, we have the two last exceptions mentioned by Marco a few minutes ago. So we have 16A with national competition rules prohibiting anti-competitive agreements, decisions by associations, concerted practices, and abuses of dominant positions. This is what I would call the traditional competition rules as we know them. Article 101, 102, and the national equivalents, right? Now, Article 19A is none of those. It does not relate to the cases that are addressed under Article 101 and 102, because it creates, if you like, it provides for per se obligations. So that is not, the legislative technique is different. And this is what leads us to Article 16B, which refers to national competition rules prohibiting other forms of unilateral conduct. Now, in order to see, as I understand the structure of the DMA, in order to see what kind of national competition rules those are, we have to read Recital 10, which gives the definition. And that definition refers to an individualized assessment of market positions and behavior, including its actual or potential effects and the precise scope of the prohibited behavior. So here, which designates the per se legislative technique, as we can see it in Article 19A. Now, we can see there that those are the elements, and of course, the efficiency and objective justification arguments. Once we have those three criteria united in or fulfilled in a national legislation, then we can be fairly confident that that legislation falls within Article 16b and nowhere else, right? And let me just make a distinction, for example, between still under your control, between 16b and 15 by giving an example. And I will still refer to the German legal order, and in particular to the Lex Apple Pay, which resembles Article 6, paragraph 7, or reminds us of Article 6, paragraph 7, as that provision was labeled, according to which, for example, an operator like Apple must give access to the NFC chip in the iPhone, right? So there, what we can see is we don't really have an individualized assessment of market positions and behavior. In order to trigger the Lex Apple Pay in Germany, you still have to serve a minimum number of clients on both sides of the market, but this does not look individualized. It is a general threshold that is in the law. So I would say that that kind of provision, which appears to lack the individualized assessment of market positions and behavior, falls under Article 1, paragraph 5. And it also falls within the scope and the subject matter of the DMA, because it is addressed in Article 6.7. And what is more, Lex Apple Pay in Germany allows the operator to charge something for that access. And it appears to be that they can charge the costs of the access, which runs counter, apparently, to Article 6, paragraph 7, because 6, paragraph 7 says free of charge. For all those reasons, Lex Apple Pay, as I understand it, cannot apply to gatekeepers on the basis of Article 1, paragraph 5 of the DMA, and not 6b. Conversely, 19a of GVB falls under 16b, and one has to assess on every single occasion whether it fulfills the conditions of 16b, and in particular, I would say the condition of further obligations, whether the obligation that is imposed on each occasion is truly a further obligation that does not intersect with the obligations as imposed by the DMA, precisely as was explained by both Alba and Marco, in order to preserve the harmonization objective of the DMA.
Thank you, Giorgio. So, Alba, there was no way for German legislation or any other member state legislation to pass this way between Stiller and Charybdis, and then still adopt the more refined, more proactive ex post competition rule, which is allowed and would be a permissible way to do, to be within the ambit of Article 16a, not to fall within Article 16b, in your view, yes?
Okay, so I would say I fully agree with George in his explanation of the interplay between 16a and b and apply to section 19a. Although I would also remark that Article 1.5 does not apply, and I think that this is something that is crucial to the interplay between national law and DMA, because it is not directed at contestability and fairness as defined by the DMA. So contestability and fairness as defined by the DMA in recitals, I think those are 32 and 33, are not addressed via section 19a. So we have the alternative view of going through to Article 1.6 to apply that without prejudice clause, if you want to call it that. Although there is also a distinct without prejudice clause within recital 12 that is more conflictive. In that particular sense, I would also say that even if from the practical perspective, even if there's if we apply or we consider that a particular practice or conduct and its analysis by the National Competition Authority falls within the scope of Article 16A or 16B, there's the same consequence will apply as a result. So that action will be permitted, and then complementarity will be attained. So I would say that is also a quite intricate analysis to perform, although I would maybe also advocate, as Giorgio did, by going through each one of the cases individually to determine whether it falls within the scope of that article or not.
Thank you very much, Alba. Marco?
So I think, Horace, you are trying to ask why Section 19A of the GVB will fall under Article 16B rather than subparagraph A. That's your question. And the answer is that I think we should think about the nature of Section 19A and the DMA. So I see both of them as sort of hybrid. We have two extremes. So on the one hand, we have traditional competition law, Article 101 and 102, that sanction ex post the conduct of certain firms, in this case, that are dominant in the market. You need to have relevant market definition. And on the other extreme, we have pure ex-ante regulation, like in the telecom sector, where you have a specialized regulator that defines ex-ante how the company subject to regulation behaves in the market. In between, we have Section 19A and the DMA. Just that the DMA is closer to sector regulation because you have these 20 obligations which are listed and the designated gatekeepers have to comply with them. Section 19A is closer to competition law in the sense that it's enforced by the Bundeskartellamt, that you don't have a notification system, but it's the Bundeskartellamt to designate the companies of paramount significance for competition across markets, so companies to which these 7 prohibitions under Section 19A are applicable, but it's still not the same like traditional competition law, because we don't have a relevant market definition. We don't have a definition of market dominance. So we are talking about different varieties of hybrids, and therefore, that's my at least explanation why I would say Section 19A is an example of national legislation adopted by the member states that sanctions other forms of unilateral conduct rather than traditional competition law.
Thank you very much, Marco. Let us move now to the issue of judicial review. George, you have recently presented at one of SERA events with a really thought-provoking speech, and you have highlighted quite a few trajectories of a possible development in judicial development of the DMA in the General Court and in the Court of Justice. What are the key theses which you would share with us?
Well, I would start by expressing again the basic distinction between what the Court of Justice does and what the General Court does. So, and I will start with the General Court, which is the main administrative court of the EU, and which has the power to hear and determine direct actions for annulment. Therefore, what the General Court does is to review the legality of acts adopted on the basis of the DMA by the Commission, and which are by implication addressed to gatekeepers, and those may be either designation decisions or further specification decisions or decisions finding infringements and so on. So the General Court, within the framework of its, within the limits of its power, would conduct a thorough review in law and fact on the basis of the application for annulment that has been lodged. The Court of Justice, for its part, has a power to hear and determine appeals against judgments of the General Court, but also has the power to rule on requests for preliminary rulings, which of course do not concern the application of the law to the facts of any specific case, but the interpretation of the law in a case pending before a national judge. Within that framework, the Court of Justice can also review the legality of a provision if that issue is raised before the national court, making the reference for a preliminary ruling. Now, as you know, the courts apply specific, they have specific rules for interpretation and specific methods they apply in turn, like they look to the wording, they look then at the context and then at the purpose of the provisions they need to interpret in order to assess the legality of an act, or in order to make a determination as to its correct interpretation. And this can happen with the DMA, as I said, either through direct actions for annulment or through references for preliminary ruling within the framework, for example, of private enforcement.
Alba, what are your views in this regard? Do you think we will have many, or we already see quite active attempts by gatekeepers to challenge even the very fact of their designation? But how would you see the evolution of these problems in the following year?
I would say now we already see those appeals coming in for the General Court. I believe Biden's, Apple, and another gatekeeper, Meta, I think, or no, Microsoft, I think, have appealed their designation decisions. And I would say that now that the European Commission has opened its first formal non-compliance procedures, maybe more appeals may come when the Commission makes some of its decisions within those proceedings, maybe on the front that Giorgio already told us about these specification decisions. And I would say, and I would highlight that we already have the first words coming out from the General Court with this order of the President of the General Court on Biden's request of interim measures, requesting to suspend the effects of some of the provisions of the DMA for Biden, especially Article 5.2 and its relationship, and it's also argued its relationship with Article 15, but the General Court did not consider that the requirements for interim measures were fulfilled, so it rejected the suspension. Although we do know that Biden's now is going to be subject to an expedited procedure within the General Court, and I would say that that particular order issued by the President of the General Court is really interesting because it also touches upon a really salient and core, maybe inadvertently and not and obliviated strand of the DMA's application, is that gatekeepers must exhaust all of the channels for seeking dialogue and seeking a decision from the European Commission before bringing those appeals to the court, because, for example, in the order, TikTok was seeking this suspension for Article 5.2, and the European Commission argued that it had not gone through the suspension procedure, that it can go through Article 9, arguing, for example, that it is not economically viable for it to apply right away the provision. And the European Commission argued that the doctrine of administrative exhaustion should apply before the claimant goes to the General Court in seeking the suspension. So I would say that quite we can also see quite some developments that maybe we could not expect coming from the General Court and the Court of Justice, and maybe also circling back to the idea of Section 19A, we also may have a preliminary ruling coming from the German courts when the decisions of the German Competition Authority are appealed at the national courts, maybe arguing that the principle of primacy has been breached. So that is a potential development too.
Thank you very much, Alba. Marco?
So about the judicial review, I would like to say the following. When the Commission proposed the DMA back in 2020, one of the underlying political reasons for that was that the judicial review by the court in Luxembourg was perceived too slow in comparison to the fast development of digital markets. Then another reason was the lack of deterrence of the sanctions imposed by the Commission in cases of abuse of dominant position. And the third reason was this risk of fragmentation of the internal market by different legislative initiatives from the member states. So we will have more expedited judicial proceedings after the DMA. The answer is no. Okay, and actually we will have many more judicial proceedings than before in cases of abuse of dominance. In a case of abuse of dominance, you can have lengthy investigation by the Commission, but at the end you have one decision which is challenged in court. Here we have plenty of Commission decisions which can be challenged in court. We can have the designation decisions as gatekeepers, which have already been challenged, and we are still waiting for an answer by the General Court, and the General Court rightly rejected the request to accelerate the procedure. We are not talking about proceeding concerning the life and death of the people, okay? And then there will be an appeal to the Court of Justice, certainly. We will certainly have appeals against the Commission infringement decisions, which are very likely to be adopted by the Commission by the end of the year, especially vis-a-vis Apple and Google after, let's say, this press release that was published few days ago. I mean, it's clear that the Commission is not happy in the way in which Apple and Google and also Meta, but for Meta it's a much more, I would say, narrow type of non-compliance. So these decisions, if adopted by the Commission after the end of the market investigation, will also go to the General Court and the Court of Justice. And then we can also have suspension decisions and exemption decisions under Article 9 and 10 of the DMA, again, decisions adopted by the Commission, in case the Commission rejects the request by the gatekeeper to suspend or to exempt the gatekeeper from the application of certain obligations. Again, this decision will go to the General Court and the Court of Justice. And on the top, we will have all the preliminary rulings coming from national courts because of private enforcement cases concerning breach of the DMA obligations, so in private litigation, and as Alba mentioned, potentially cases of preliminary rulings from administrative courts that review the decisions of National Competition Authority concerning the breach of the DMA obligation. So overall, I think we will have a proliferation of cases, and the gatekeepers clearly have deep pockets and interest to postpone as much as possible compliance with the DMA obligation. That's clear. And we will have the resources and the interest to fight for their rights, whatever, in court. So clearly the DMA has not achieved one of the initial political objectives why the Commission adopted this legislation, why the Commission proposed this legislation back in 2020.
Thank you very much, Marco. George, you have further elaborated on the point that there are two types of specification decisions. One is adopted individually within Article 8.2, and another is under Article 12. where we are talking about adopting decision under the delegated act. What would be the differences in reviewing the legality of these decisions?
Right. Can I, before starting, can I make a very brief point concerning what Marco just said on judicial review? Yes, I think that Marco is quite right in pointing out that the DMA, because of its nature and because of the fact that it requires a designation and it can give rise to a variety of decisions and not one single decision, as is the case with competition law, may give rise to litigation and to litigation at various stages of the same broader case or of the assessment of the same broader practice. However, may I just say that the context is a bit different in the sense that as I understand it, what the DMA wanted to achieve is a clearly defined set of obligations that are enshrined in the law itself. It is not a general clause-like type of legislation whereby we're looking for anti-competitive effects. The Commission is looking for anti-competitive effects and then puts them down in a decision, and then the General Court and on appeal the Court of Justice are trying to find out in the light of the application whether the Commission was right or wrong on quite complex matters. Here, the bulk of the issue as to whether an obligation exists has been resolved by the legislature. So yes, Marco is absolutely right in pointing out that we may have litigation, but the nature of that litigation will be different. And I will certainly join Marco in saying that the ultimate success of the DMA as a tool will be judged, among other things, on the basis of its rather limited justiciability, if you like, or the limited resources it will end up using, possibly in a few years' time, when everyone will know, or it will be common knowledge, or what the obligations are. And it will hopefully at some point function more between or more within the framework of a regulatory dialogue and less by litigation. I don't know if Marco agrees on that, but I think that will be the final metric of the success of that piece of legislation. And of course, that's without prejudice to any plea that may be raised on the legality of any provision of the DMA, which will be determined by the courts, of course. So,
and you think that the obligations will be, the substance of obligations will be refined by the court ultimately?
Oh yes, but of course this is an ongoing process, and I think there will be challenges in terms of interpretation. Challenges, I mean, issues that will have to be determined as to how a provision must be understood and interpreted. But again, I think that the ultimate success will be possibly more regulatory dialogue and less litigation. But I would like to think that this will be the result possibly in a few years' time, maybe not immediately.
So let us pause here, George, and then in the next cycle we will revert to the question which I asked before, because I wanted to ask Marco and Alba's views on the substance of regulatory dialogue. Alba, you monitor obediently all the compliance workshops and report to broader competition public again on the daily basis, all 6. You examined the non-confidential versions of compliance summaries, etc. Do you sense there is a kind of the spirit of regulatory dialogue as outlined by George, that it should be non-litigious, more kind of daily routine where we somehow try to refine each specific provision in the context of our specific core platform designated core platform services? What is your view on this? How plausible the scenario outlined by George is?
I would say I was quite positive for the last week but when the non-compliance proceedings were opened, although opening those non-compliance procedures do not necessarily mean that gatekeepers will be fined in the end. But I would say I was quite positive until then, but then my view changed a bit when viewing and in listening to all of the gatekeepers possible or their compliance solutions within the compliance reports and some of the adjustments that they have done throughout the workshops and throughout these few weeks, I would say that most of them, not all of them, are quite prone to this regulatory dialogue. But I would also stress that for a dialogue to take place, there must be two parts, and there must also be a trust relationship between those two parts. So if I was a gatekeeper and I thought, oh, okay, I'm going to engage with the regulatory dialogue with the European Commission, and in that way we will interpret in a I would say in an established way between us how a particular provision should be applied. For me, I would not say that each of the provisions will be applied transversally for all of the gatekeepers, because different types of core platform services are comprised within the provisions, and even within those categories of CPSs, not the same consequences will not radiate to those types of services, even if they belong to the same category. So maybe the scope for regulatory dialogue will take place within the non-compliance procedures. I would expect the European Commission to maybe do so before going really hard on the gatekeepers. But I would also stress the need to preserve at least this trust relationship with the European Commission between the gatekeepers, and also with the gatekeepers, with the third parties, and also the business users and the end users that are also using their services for the enhancing of contestability and fairness. So to that point, I would say I was positive, but then I was a bit disillusioned with the opening of the non-compliance procedures. But this is only the start, I would say, and we may see some changes coming from the gatekeepers' perceptions and also from the European Commission's perceptions maybe in the next year. So.
Thank you very much, Alba. Marco, how do you see the development of the last 2 weeks in this regard? Do you come to the dialogue with open hand, or rather showing the weaponry hanging on the wall peacefully? What's the better strategy, or select the one picked by the enforcer?
Yeah, that's a very good question, Oles. So I think the Commission so far has really tried hard to engage in a regulatory dialogue. So remember last year when the DMA entered into force, the Commission organized this series of workshops inviting the gatekeepers, but also academics, other stakeholders to discuss how the individual DMA obligation should be applied in practice. Okay. The Commission did not express any view during those workshops, or just sharing them. And then I found also positive the Commission initiative. These are pure initiative by the Commission. It's not required to do so in the DMA, to organize this compliance workshop in the last couple of weeks after the non-confidential version of the compliance report was published on 7th of March. And I think, as far as I heard informally, there have been a lot of meetings between the Commission and the gatekeepers in the last couple of months. Also, I have to notice that in this press release where the Commission announced the opening of the investigation, as far as I remember, the Commission also accepted to postpone for Meta messenger service the interoperability obligations under Article 7 because of technical difficulties in ensuring interoperability under Article 7, which are well known. So I think the Commission has tried, okay? On the other hand, the gatekeepers, I have also followed the workshop, not probably as extensively as Alba did, but in all the workshop, the gatekeepers started presenting the way in which they comply with the obligation in this way. We have implemented the DMA obligation by letter, and we have tried to come up with solutions who are the best for our consumers. They safeguard their privacy and security. Privacy and security are not relevant considerations under the DMA. Let's make it clear. So I think at the moment there is a mismatch between what the Commission expects to achieve with the implementation of the DMA obligation, opening up markets, I don't know, and ensuring fairness, and what the gatekeepers are ready to offer. And then I think some kind of judicial proceedings at the court will be inevitable in this phase. And as George mentioned, would be the court to better frame, revise, refine the scope of the DMA obligation. That's clear. In individual cases, just that it will take a lot of time, okay? It will take years and years before we fully understand the scope of the different DMA obligations.
George, and now thank you, Marco. And now I pass the floor to you to articulate the key messages. Marco mentioned already, alluding somehow, that privacy and security are not relevant to the DMA, but to some obligations it is explicitly referred to. Somehow, to others, we see, even within artisan convention provisions, we hear that the gatekeepers have to comply with other obligations of EU law. How to create this side dish, how to create this cocktail of different obligations, different interests, from juristic point of view?
Yes. So about Articles 8 and 12, you would like to discuss later.
Yes. You can combine both.
I fully agree with Marco on the fact that privacy and security are not amongst the objectives of the DMA. That is absolutely clear. However, as is very often the case with competition law, it is always a debate between, or always an exercise of distinguishing between anti-competitive and pro-competitive features of a practice. So with the narrow exception of per se legal practices, all the other rule of reason assessments always have to make that distinction. So we have a practice which may feature both anti-competitive and pro-competitive characteristics. And what we see in Articles 6.4, 6.7, or 7 is a reflection of that reality. So the gatekeepers must open the gates, allow interoperability, but they are also allowed to maintain features, parts, or aspects of their practices that have a pro-competitive rationale, that allow developers and other operators to function within an environment that is reasonably secure, and therefore provides is a correct system, or the appropriate system, for both business users and end users to evolve in. And I think this is a reflection of how competition law works more generally. So the DMA, and which gives us a very good example of a potential example of application of Article 1.6b. Let's say if a member state adopted a provision similar to Article 6, paragraph 4 on vertical interoperability, but did not allow the gatekeeper to adopt measures that have the objectives of integrity and security as provided for in Article 6.4, right? So that would be an obligation, a national obligation imposed on a gatekeeper that intersects with an obligation under the DMA, but simply raises the bar, makes the obligation more strict, more pronounced. That is not a further obligation, as I understand it, within the meaning of Article 1.6b, and possibly cannot be allowed. That is my personal interpretation. By the way, whatever you hear today is my personal views. It has nothing to do, it does not engage the court on anything. So So I think that's that is how it is meant to work. I don't know if I have answered your question as.
Yes, you did. And maybe now we can revert to different types of specification or legal implications for different types of specification decisions, individual and.
Yes. So your question about Articles 8 and 12. Right. So under Article 8, we have the procedure for an individual specification decision, and where the Commission has a discretion as to whether they want to engage in that procedure in order to further specify an obligation under Article 6. But that is a procedure that culminates in the adoption of an individual implementing act addressed to the gatekeeper. And that is why, under Article 8, Paragraph 7, the Commission has to make sure that the specification is proportionate in the specific circumstances of the gatekeeper and the relevant service. That is how the principle of proportionality will apply here. However, you don't have that when the Commission exercises a broader power to further specify obligations, by the way, under Article 5 as well, which is not available within Article 8. When the Commission tries to do that under, or undertakes to do that under Article 12, Paragraph 2, where they can specify by way of a delegated act, which is an act of general application applicable to all gatekeepers. And there you will not see a reference to the principle of proportionality within the meaning or in the same way as you see it in Article 8.2, but there is a different requirement that the Commission must satisfy, which is that the further specification is necessary in order to ensure effective compliance with an obligation. So again, the Commission must explain, as I see it, why the specification is necessary in order to ensure effective compliance. And thereby, it is not a mere choice of the Commission between two equally effective ways to comply with an obligation, to impose one of those by way of a delegated act under Article 12, Paragraph 2. Paragraph 2 or Paragraph 4, for that matter. Paragraph 4 relates to, it's a further specification for Article 7. And there is also another question with regard to Article 8, whether the Commission enjoys discretion when they further specify, if they choose to further specify in an individual case. And if I have 1 minute, I could offer some basic principles under which we can assess whether the Commission has a discretion and choose one type of specification over another. Now, I would believe that in order to say that the Commission has discretion in that matter, we need to have a case in which there is more than one way to comply with an obligation. So you have at least 2 ways to comply with an obligation, and both of them are equally effective. Both of them are equally burdensome for the gatekeeper. That's because of Article 8.7, which obliges the Commission to, if you have both equally effective ways, to choose the less burdensome, right? And in order to say that there is discretion, we would have to accept that the Commission has the power to impose one of those equally effective and equally burdensome ways to the gatekeeper. My question is, how would the Commission justify the choice between 2 equally effective and equally burdensome ways to comply? It is a little bit difficult to justify, and I'm not sure the Commission has ever done this in competition cases where they impose obligations, for example, within a final decision. So I think I would tend to believe that the power to further specify as given to the Commission, as conferred upon the Commission under Article 8, is more about legal certainty and less about exercising some form of discretion. Of course, the situation is completely different, and I will end my comment with this. If the envisaged ways to comply are not equally effective, then of course the Commission has every right to impose the effective way to comply. But that's not about discretion. That's about a direct application of the obligation.
So the impression
Florence,
is, yes, Marco, go on.
Can I ask a question to George about Article 12? Because I found very fascinating what he was saying. And we were talking before about judicial review of Commission decisions under the DMA. So do you think that gatekeepers would have legal standing to challenge a delegated act adopted by the Commission under Article 12, refining the list of obligations under Article 5 and 6? Would they satisfy the Plowman test under Article 263 of the treaty? Personally, I think yes, but I wanted to hear your view about that.
Yes, that's an excellent question. I would say that, of course, exactly as you said, it is a matter for the application of Article 263. A delegated implementing act, a delegated act under Article 12.2 is an act of general application. And it is an act that I think we both agree will not entail implementing measures at any level, which means that a gatekeeper will simply have to show that they are directly affected by that act, given that that act will be a regulation and that it will impose obligations on that gatekeeper. So subject to that condition that the gatekeeper has been designated for a CPS that is addressed, that is concerned by that act, I would tend to believe that yes, they would be, as a matter of baseline scenario, they would be admissible to bring an action for annulment, an action seeking the annulment of such a delegated act. The standard of review, however, would be a different issue, because as we know, acts of general application are not assessed in exactly the same way as individual acts, especially insofar as proportionality is concerned. But even before proportionality, there is also scope for judicial review of all the conditions for the adoption of a delegated act under the DMA, read in the light of the relevant provisions of the treaty.
Thank you, Giorgio, Marco. But how do you see this kind of? We remember the ethos of discretion, which was in the era when in the month when the DMA was discussed, discretion for the enforcer, single enforcer. But now we see that the principle of proportionality in its different incarnations constrains these discretionary competences of the Commission, even when we talk about obligations susceptible for the specified and thus narrowed down and thus not applicable ex tunc, ex nunc. So these kind of issues which somehow shifts the intent or the incentive to knock on the door from the Commission to the gatekeeper. They are interested in further specification. They are interested in launching and intensifying this dialogue. Do you think that ultimately the traditional pillars of EU law will somehow evaporate this enthusiasm? Was it too naive to believe that the Commission will be able to tailor obligation and refine obligation depending on what is envisaged in its ideal scenario for the benefits or for achieving fairness and contestability?
I would say you can break down that same question into many sub questions, because first of all, to achieve fairness and contestability, we must know what fairness and contestability stand for, and that is quite a huge feat to perform, insofar as contestability and fairness may not mean the same thing as they do for antitrust. And even then, when we go back to the definitions of fairness in antitrust, they apply differently to different scenarios. But I would say that in terms of discretion, I don't see the principles of EU law evaporating as a result, but I do see that the European Commission has a great challenge ahead of itself to try to specify and to try to deliver this nitty-gritty detail that the DMA is aimed to deliver on, and maybe as a middle ground, because I was thinking and I went back to the DMA to check that maybe as a middle ground between the specification under Article 8 and the specification under Article 12, we also have this possibility that the DMA, that the European Commission issues guidelines under Article 47. So maybe there's also like an alternative view or an alternative pathway for the European Commission to pursue to try to apply general rules, or maybe it will only reserve the power to do so under Article 47 for procedural rules. I'm not sure. But in any case, I also see that maybe this principle of proportionality has not really permeated as of now with regards to the European Commission's actions. As I see it in my own mind, for example, one example that comes to mind is the fact that the European Commission has only issued one implementing regulation as of today, relating to the gatekeepers' notifications to the European Commission, but it has issued a wide array of other regulatory templates that did not follow the procedure via the DMA Implementing Act, and they were just published within the DMA website, and then they can even be updated whenever the European Commission decides, and they will apply automatically to the gatekeepers. For example, one such regulatory template was passed under Article 14. I believe it was early summer, and then it was also updated without any notice by the European Commission to apply, and the update applied and regarding the transparency obligations that the European Commission had imposed on itself in the initial version of that template. For example, the European Commission was compelled to publish all of the list of the acquisitions that the gatekeepers realized in the market, whereas the second version delayed or lacked that period for 4 months. So now we have that 2 acquisitions have been notified and have been included within the website, but 3 acquisitions were notified by the European Commission within that period, and maybe they are within the 4th month time frame, because the annual report that the European Commission issued remarks that 3 acquisitions have been performed. So maybe the principle of proportionality and the degree of discretion that the European Commission applies may well be off a track, I would say.
Thank you very much, Alba, for extending further this complexity and these challenges which we will be witnessing with professional interest. Marco, I'm mindful of time, but I cannot resist the temptation to ask you you have recently co-authored a paper where you deal with the issues, the relationship between competition law and privacy, GDPR, for quite a long time. But you have also co-authored a paper examining the relationship between DMA and GDPR. And we see that the obvious, there is one gatekeeper with most plausible and most direct implication for this relationship, Meta. Can you maybe highlight to us the key messages, the key takeaways of the paper in conjunction with the launching a new investigation?
Thank you, Oles. Yes, indeed. It's a working paper that was published a few months ago. It's available on the UI website. I co-authored it with Daniel Borges, who is a data protection expert. He's a colleague of mine at the UI. So the paper, it's about Article 5.2 of the DMA, which is for those of you less familiar with the DMA, it's the obligation whereby the gatekeepers cannot cross-use and merge personal data collected within the ecosystem. Okay, so there is a general prohibition, and then there are some exceptions. The main one is the use of consent. So the gatekeeper managed to collect a consent compliant with the conditions for a lawful consent under Article 6.7 of the GDPR. So this is the link between the DMA and the GDPR, is the consent, let's say. So in the paper, what we try to discuss is first a general, let's say, what is the general relationship between the DMA and the GDPR, and then we specifically talk about how to design a valid consent under Article 5.2. We wrote the paper before the DMA compliance report, so probably now we will have to revise it. So talking about the general relationship between the DMA and the GDPR, we argue that they are both regulations. They have the same status within the hierarchy of legal norms. They have different objectives. And in our view, the DMA takes care of a narrower set of facts and circumstances in comparison to the GDPR, which is generally applicable. And then to cut the story short, we basically argue that the DMA is a lex specialis in comparison to the GDPR. And this has some repercussions for what we argue in terms of consent design, because some data protection authorities in Europe have argued that cookie walls do not represent a valid form of consent under the GDPR. And in our paper, we argue that because of the lex specialis stories, the consent under the DMA should be adapted to the peculiarities of the DMA, and specifically to the fact that under Article 13, under the anti-circumvention rule, dark patterns are prohibited, so requesting several times consent on the side of the users, as the approach under the GDPR, would represent in itself a breach of the DMA. So talking about now compliance, which since we have read the reports, so something that came out about Article 5, Paragraph 2. So first of all, this is an important obligation that all gatekeepers have to comply. Okay, that's clearly not only something for Meta, but also Google, ByteDance, even Apple had specific paragraphs, sections in their compliance report about how they comply with Article 5, Paragraph 2. Clearly, it's more relevant for the gatekeepers who basically have a business model based on personalized advertisements, Google and Meta, and also ByteDance. Another point is that no gatekeepers, to my knowledge, so far as decided to comply with Article 5, Paragraph 2, opting for a ban on cross-use of personal data, at least to my knowledge. Maybe Alba, we have a different view because she has followed more carefully the implementation. And then I think those basically the general approach in terms of compliance has been to opt for this sort of cookie walls where the users can decide what type of data merge you accept. Do you accept to merge your personal data collected via the use of Facebook with WhatsApp rather than Facebook with Messenger, Facebook, Instagram, and so on. So I think that the Commission has mostly accepted this way of implementing with, let's say, Article 5.2. From the press release published by the Commission a few days ago, it has been mentioned that the Commission started infringement investigation vis-a-vis Meta, not specifically for the way in which this cookie walls appear, let's say, but my understanding because of this consent versus pay approach introduced by Meta. So Meta basically has comply with Article 5, Paragraph 2, introducing, as you probably know, a subscription fee of, I think, almost 13 euros per month, let's say, to have a no-ads version of Facebook and Instagram. And within this new version, basically, there is no cross-use of the data. So it's also a way to comply with Article 5, Paragraph 2. Meta did it because of the ruling of the Court of Justice in the German Facebook case, where in paragraph 150, the court said that users should have the possibility to have two alternatives between a version of the social service based on advertisements, personalized advertisements, and another one where users pay a subscription fee and they don't watch advertisements. On the other hand, some data protection authorities, I think from Hamburg, the Netherlands, and Norway, has submitted a complaint to the European Data Protection Board, arguing that the choice between a free, let's say, between consent versus pay, so you have to pay, let's say, in order to get this free version, undermines the concept of free consent, okay, that makes invalid the concept as such. I don't have an answer to that. My personal view and what I will argue in the paper is that gatekeepers are basically not charity organizations, are business operators. So when we get a social service, a digital service, we pay for it. And I'm more sympathetic towards the approach followed by Meta. I don't think it's in breach of Article 5.2. The DMA does not say that the less personalized by equivalent service should be provided for free by the gatekeeper in case the users does not provide the consent. So I think actually users now have a choice. But maybe I leave it to Alba, who has also worked on Article 5.2 and follow closely the workshop about the DMA implementation.
Okay, so on the prohibition, because Article 5.2 is also quite near to my heart, because I also published a paper on this, edited also in an edited journal by Marco directly. So Article 5.2, as Marco rightly pointed out, establishes a prohibition by default, and then the exemption overrides that prohibition. And Marco upholds this idea that some of the gatekeepers may not comply with that prohibition within the compliance solutions that they have put forward, because their compliance solution is saying, look at these choice screens that I'm displaying to the users so that they can consent for the processing of the prohibition, whereas they do not apply in some cases the prohibition right away within their data layers and infrastructure. But and a caveat on Marco's perspective, indeed, surprisingly, Apple does comply with Article 5.2 with respect to the App Store data, and it's said within those few paragraphs of its compliance reports that when it identified cross-used or combinations of personal data, it ceased to use them, and it did not design any choice screen to that objective. And on Meta's,
because it's not based on advertisements, it's business models. Yeah, good point, Carl.
And also on Meta's pay or okay consent, also stemming from the workshop, it was quite funny to end up the discussion. I said that they said we are an equivalent alternative. We are giving an equivalent alternative through the subscription, and we are quite competitive as opposed to our peers, such as Netflix, subscription service that is also charges a similar fee. But within the workshop, it highlighted that it was going to lower its fee. So maybe quite a conflictive statement to make within the workshop, I would say.
This is an amazing trajectory of our conversation. And I hope, and I'm quite confident that with this kind of rapid development in in the sector. We will have many opportunities to reconvene in different configurations, focusing on different aspects of this. But I'm mindful of time, and I wanted to close this really inspirational conversation by asking for your recommendations, maybe specifically to the kind of new professional experts working on the DMA compliance, or maybe on trying to expand the boundaries of the DMA. Which new features would you recommend to our students to train for becoming professionals in the field in the following years? Maybe George, start with you.
Yes, I would strongly recommend to study as many judgments of the court and the general court as possible that relate to interpretation and application of provisions that impose obligations on individuals. I think it is quite important and useful to get the spirit of the technique relating to interpretation and application of that kind of provisions.
Amazing. Thank you very much, George. Marco?
Yeah, that's a very good question, Oles. I think I would say law and technology. Okay, that's the future, and not so many lawyers have a clear understanding about the technology. We talk about these different platform services and different functions, but to understand the technicalities behind what is feasible or not in terms of compliance is something different. And I think it's also a big challenge that at the moment the Commission is facing internally, let's say.
Absolutely. Thank you very much, Marco. Alba?
Building upon Marco's response, and also borrowing from it a bit, I would say that it is also worth one's time to go through on the DMA does not directly consider those economic considerations, but mainly consider the economics behind the digital platforms, and how those DMA provisions may permeate those economics and may impact them.
Many thanks indeed, Alba. George Gryllos, Alba Ribera Martínez, Marco Botta, thank you very much indeed for this really inspirational conversation. It was a pleasure to having you here.
Thank you very much.
Thanks a lot, Oles. Thank you.